really coming to you in what are effectively unprecedented times. The reason why we're having to have this webinar is, of course, that it would be very dangerous for us all to come face to face and do this lecture and presentation how we would usually do, where we're all together. And to think that maybe even a couple of weeks ago, what we're doing now and gathering together, if we'd done this face to face, may well have been against the law, and we could have all been fined for failing to comply with social distancing. So as we move into these unprecedented times, I feel that a topic that is likely to be occurring regularly in our contractual issues is that of frustration and force majeure. And that's what I'm going to talk to you about today. The structure of our presentation today is going to be starting off looking at frustration. We'll go into the definition of frustration, look at its origins, conceptual foundations. We'll look at the test that applies in frustration cases. We'll look at the consequences of frustration, both at common law and under statute. And we'll try and have a bit of a brainstorm, really, in respect of how these frustration issues are going to be impacted by the COVID-19 crisis. We're also going to be looking at force majeure. We'll look at the definitions of force majeure, we'll look at its scope, and again, we'll do a bit of a brainstorm effectively on how force majeure may well be affected by the COVID-19 issues that we're currently experiencing. Now, the definition of frustration has been helpfully set out by Bingham, Lord Justice Bingham, setting out 5 propositions within his, there we go, setting out 5 propositions that he says are effectively set in stone as regards frustration. And I've set those out in these 5 points that you'll see on the presentation here. And what we've got is the doctrine of frustration has evolved to mitigate the rigour of the common law's insistence on the literal performance of absolute promises. The object of the doctrine was to give effect to the demands of justice, to achieve a just and equitable result, to do what is reasonable and fair as an expedient to escape from injustice, where such would result in the enforcement of a contract in its literal terms after a significant change in circumstances. The second proposition point is that since the effect of frustration is to kill the contract and to discharge the parties from further liability under it, the doctrine must not be lightly invoked and must be kept within narrow limits. The third principle proposed by Lord Justice Bingham is that frustration brings the contract to an end forthwith, without more and automatically. It does not require an act by the parties to the contract. The fourth proposition, the essence of frustration is what it should not be due to the act or the election of the party seeking to rely upon it. And then the final proposition is that a frustrating event must take place without blame or fault on the side seeking to rely upon it. So that's effectively the definition of frustration. If we look at its origins, and this is quite an interesting case that we've got here, is Taylor and Caldwell, goes back to 1863. And the facts of that case relate to the hiring of a music hall and some local gardens. Now, the purpose of those hirings was to have the music hall and the gardens available on 4 specific dates. And having looked at the case, I can see that the entertainment included that evening was to involve a military band, fireworks, there was going to be singing and performing inside the music hall, there were going to be tightrope performers, there was going to be a special appearance from Mr. Sims Reeves, and rather interestingly, there was going to be a wizard and some Grecian statues. So, nights of merriment planned on 4 specific occasions. When the contract was entered into, everything was well and good. However, following the entry into the contract, unfortunately, the music hall burnt down, and so therefore was no longer available for the presentation of all of those wonderful activities. And I'm sure that the wizard must have been terribly disappointed. But the state of the existing law at that time said that when a supervening event occurs that hasn't been foreseen by any of the other parties, the typical rule then was that you would expect the parties to continue with the performance of the contract or suffer the consequences of the breach. The reason for that is that the law at that time considered that should you face one of these frustrating events, then this is something that you could have effectively predicted when you were making your contract. So it was a time of the freedom of contract. And the general feeling was, well, actually, you should have anticipated this. And if you haven't anticipated it, that's your problem. So the doctrine of frustration is generally considered to have been born within Taylor and Caldwell, where the judges in that case decided that actually there was an implied term, or there was a term to be implied within the contract that said, in the event that a supervening event occurs rendering the subject matter of the contract destroyed, that in those circumstances, there will be no obligations continuing forward. Now, the use of that was effectively the implied term. And at the start, it was restricted to situations where generally things had been completely destroyed and it was completely impossible to rely upon them. The case of Taylor and Caldwell started the ball rolling effectively. And what the courts had to do was they had to establish a careful balance between parties, preventing parties from trying to escape from bad bargains, and also bearing in mind that it is possible for parties in contracts to come to specific agreements about what might happen in the event of a supervening event. So it's those two aspects on the one hand, avoiding these bad bargains and allowing the liberty and freedom of contract. And on the other hand of that, there's the injustice of being held to an agreement that's been rendered impossible or radically different through an unforeseen supervening event. And the courts had to try and come to some kind of balance between these two effectively conflicting ideas. And this brings us on to the conceptual basis behind frustration. Now, the conceptual basis behind frustration has led to quite significant debate. And we are much assisted by a recent case, which is Canary Wharf BP 41 Limited versus European Medicines Agency. It's a 2019 case from the High Court and was decided by Mr. Justice Smith. Effectively, the case very, very carefully looks at the various conceptual bases that have been put forward over the years for frustration. It confirmed the end of the implied term that we saw way back in 1863. And effectively, we've moved on quite considerably from that implied term concept. And the reason why implied terms don't work so well with frustration is because if we think about how implied terms work with the officious bystander, for example, if the officious bystander were to say to two people who are making their contract, oh, well, what would happen if your music hall burnt down? The parties aren't likely to say, okay, that would be the death and the end of the contract. What they're likely to say is, okay, if the music hall burns down, we'll include some method of compensation or we'll put some alternative in there. And effectively, the whole point of frustration is that it's an unforeseen event. And so the idea of bringing this officious bystander in and saying what will happen if an unforeseen event occurs simply didn't tally up. And so this concept of the implied term, we've moved on from there. We've gone through a number of different approaches over the years. But the situation where we are now is the courts adopting what's known as a multifactorial approach. And Mr. Justice Smith quoted at some length from the approach that was taken by Ricks LJ in the Sea Angel. And it's particularly useful if we see what Ricks LJ said, which is, in my judgment, the application of the doctrine of frustration requires a multifactorial approach. Among the factors which had to be considered, the terms of the contract itself, its matrix or context, the parties' knowledge, expectations, assumptions, and contemplations, in particular as to risk, and as at the time of the contract, at any rate as far as these can be ascribed mutually and objectively, and then the nature of the supervening event and the parties' reasonable and objectively ascertainable calculations the parties in the new circumstances. That's all well and good. The conceptual side of things and the academic side of things is, of course, important. But the reality is that we're going to have a number of clients coming to us saying, well, what's happening about this contract? I think I've been affected by the lockdown, or I've been affected by the direct consequences of the COVID-19 disease. I think the best way to phrase the frustration test is as I've set out here. So the first test that we need to look at, the first element of the test, is that there's no provision for the event within the contract's express terms. The second element is the event renders the performance of the contract impossible, illegal, or radically different from what was contemplated by the parties. The third element is the event occurs after the contract has been formed. The fourth is that the event is beyond what was contemplated by the parties entering the contract and is so fundamental that it strikes to the root of the contract. And then the final element is that neither party or any of the parties involved in the contract are at fault. So this first element of the test is that there's no provision for the event within the contract's express terms. I've used the phrase express terms here as part of being careful, really, in respect of the case law that we've seen regarding implied terms. However, there can be implied terms that would prevent frustration operating within a contract, or implicitly prevent frustration operating in a contract. One of those might, for example, be an obligation on the parties to insure for a particular event. If that event occurs and they have an obligation to insure for it, then they're not going to be able to rely upon that as a frustrating event. The express terms are there and able to foresee and allocate a risk. And so it's all part of the concept of frustration that we continue to have this freedom of contract, which allow parties to anticipate what they would do in the event of a supervening event. The next element of the test is that the event renders the performance of the contract impossible, illegal, or radically different from that was contemplated by the parties. Now, thinking of a situation in which that is impossible could be easily done. That's the same example as our music hall in Taylor and Caldwell burning to the ground. In that case, it was impossible to fulfill the contract because the elements of the contract that had been hired no longer existed. The principle of a contract becoming illegal is not actually an unusual one. As regulations and statutes change, you may find that a particular service that you contracted to provide suddenly becomes subject to licensing requirements, or may even the product that you are supplying has been declared an unlawful product and reclassified. In those circumstances, if the essence of the contract becomes illegal, then clearly it can't be fulfilled. So impossibility and illegality are two quite clear concepts. One concept that is perhaps a bit more difficult to get our heads around is this idea of the contract and the obligations being rendered radically different. We're much assisted by the case law that's looked into this radical difference approach. The case of Davis Contractors Limited versus Fairham UDC. It's a 1956 case and concerned a number of building contracts that had been interfered with as a consequence of people not being released and demobbed from the army as quickly as people had hoped. And so construction contracts had been arranged in anticipation of having a wider source of labour. And then as a consequence of difficulties with the demobbing, that labour wasn't available. We are assisted by Lord Justice Radcliffe, who there refers to the fact that there must be such a change in the significance of the obligation that the thing undertaken would, if performed, be a different thing from that contracted for. And Lord Justice Reed, in the same case, said the question is whether the contract, which they did make, is, on its true construction, wide enough to apply to the new situation. If it's not, then it's at its end. There are other important inputs in respect to this radically different test, and I particularly like the one that Simon LJ provided in National Carriers versus Panalpina Northern Limited, and I've set that out here for you. It says a frustration of contract takes place when there supervenes an event without default of either party and for which the contract makes no sufficient provision, which so significantly changes the nature, not merely the expense or the onerousness of the outstanding contractual rights and or the obligations from what the parties could reasonably have contemplated at the time of its execution, that it would be unjust to hold them to the literal sense of its stipulations in the new circumstances. In such a case, the law declares both parties to be discharged from further performance. I think that is a very rounded and clear summary of the tests that we look for in frustration, but it does provide us with this confirmation of the importance of obligations being radically different. Now, in order to determine whether the obligations have been rendered radically different by the supervening event, the first step is effectively to compare those obligations. So look at the contract and see what the obligations were as set out within the agreement between the parties. Obviously, if the contract's in writing, it's far easier to determine that. However, if you're relying on an oral contract or a contract that's been developed by custom and trade, then things will get a little bit more complicated. If you establish what the obligations are within the contract and then look at how they've been affected by the supervening event, there are a few cases that can assist us in looking at this situation and give us some examples of how it's been applied in practice. There are a number of frustration cases that stem from the cancellation of the coronation of Edward VII in 1903. Edward VII was unwell, unable to attend his own coronation. Lots and lots of celebrations had been prepared in anticipation of him being crowned king, but unfortunately he was unable to participate at that time, and everything had to be suspended and a new time set for the coronation. Now, from those coronation cases, we find the case of Crell and Henry. A 1903 case dealt with in the King's Bench division. And in that case, the parties had agreed to rent rooms. And the rooms were intended to be used to witness the parade of the coronation as it went past. They were effectively just rooms of the view. Now, an important aspect about the contract within Crell and Henry is that the rooms were only rented for use during the day and not at night. When the announcement was made that the coronation was going to be cancelled, that was classified as a frustrating event, because the essence of the contract between the parties was viewing the coronation. The only purpose really between them, the hirer and the hiree, was to enable people to look out the window and see the king going past. When that wasn't possible, the obligations were radically different. It wasn't impossible to rent the room for the day, but the reality was that what the parties had contracted for was radically and considerably different. The person who had rented those buildings clearly didn't want to just sit there and watch the traffic go past. So this is an example where it's not impossible, but the substance of the contract has radically changed. There's another case, FA Tamplin SS Company Limited and the Anglo Petroleum Products Company Limited. This is a wartime case. It involves the charter of a vessel for 5 years. And the charter was interrupted by the requisitioning of that vessel in order to become a troop ship during the First World War. There were certain restrictions on First World War ship requisitioning, which meant that it was likely to only involve a couple of months at most, and the ship would have to be returned. The court looked at the whole circumstances and came to the conclusion that a couple of months of interruption during a 5-year charter party was not going to be enough to cross that limit to render the obligations radically different and so amount to a frustration. And this is quite an interesting line of case law that we see in respect of the interruption of charter parties. And it's something that I think may well be relevant as we move towards our sort of brainstorming in respect of COVID-19. One case that's of particular assistance is Bank Line Limited and Arthur Capel & Co. There, the court came to the conclusion that the main thing to be considered is the probable length of the total deprivation of the use of the chartered ship compared with the unexpired duration of the charter party. The probabilities as to the length of the deprivation are not the certainty arrived at after the event are also material. The question must be considered at the trial is it had to be considered by the parties when they came to know of the cause and probabilities of the delay and had to decide what to do. Now that quote's particularly important because it really deals with that question that we would always have in a frustration case of, has this contract got to that stage where it's frustrated? Have we experienced a frustrating event that would enable us to treat this contract as effectively being killed off? And the court has made it very clear there that the key time for looking at this is when you have to make that decision about the frustration. And this might be particularly important in a COVID-19 situation because, of course, the rules that we have regarding social gathering and the opening up of non-essential shops, etc., are evolving and changing. And it's very difficult for us to predict how those rules are going to be moving forward and when they're going to change. So people are making very important decisions at the moment about whether their contracts have been frustrated. It's important to get that decision right, because if you elect to frustrate a contract and you haven't fulfilled the frustration test, then you will be seen to be repudiating the contract. You'll be giving a clear indication to the other side that you have no intention at all of continuing with your obligations. And in those circumstances, the other side can treat you as in breach, consider the contract to be repudiated. And obviously the consequences of a repudiated contract are very different to those of a frustrated one. I've referred here to the case of Herne Bay Steamboat Company Limited in Hutton. This is another coronation case and another case where there was a hiring taking place. But in this situation, the hiring was in respect of a vessel. It was a steamboat. And the purpose of the hiring was declared to be for viewing the National Review at Spithead and for a day's cruise around the fleet. Now, the National Review at Spithead was cancelled as a result of the king being ill and unable to attend the coronation. However, the hirers of the steamboat said, well, actually, you can still have your day's cruise. And in those circumstances, the court found that actually this contract hadn't been frustrated. The obligations that were in existence between the parties had been changed, but were not radically different. The speculation that a lot of people say within these coronation cases is that, Herne Bay Steamboat Company, there was still a large element or a substantial element of the contract that could be fulfilled. In Crell and Henry, that wasn't the situation because the rooms had only been booked for the daytime. If they'd been booked for the evening as well, in a sort of hotel sort of situation, then it may well be that Crell and Henry would have had a very different result. So looking at this radically different concept, it is a question of fact and degree. And one of the things that I find particularly interesting is that we'll see from our quote from Panalpina, and we're going back a slide now, where it specifically says that the contract is significantly changed in its nature, but not merely in the expense or the onerousness of its fulfillment. And that, I think, is a key point. Just because something is going to be rendered slightly more complicated or something is going to be rendered slightly more expensive by the supervening event does not necessarily mean that the contract is going to be frustrated. The courts are reluctant to frustrate contracts, and there needs to be something that goes beyond just a reduction in profit. And this is, I think, going to be another key point as we move forward, considering the impact of COVID-19 on many of our contractual relationships. If we continue with the frustration, the test of frustration, the next element is that the event occurs after the contract has been formed. And this is a key distinction between frustration on the one hand and mistake on the other. So if you have a situation where there is a mistake, the mistake, it will be in force and there'll be a misunderstanding at the time that the contract is entered into. So if you are, as contracting parties, both mistaken about the subject of your contract matter, that will be the case when you shake hands. The whole distinction and importance of frustration is that a supervening event occurs after the contract has been formed. The next stage in respect to our frustration test is that the event is beyond what was contemplated by the parties entering the contract and is so fundamental that it strikes to the root of the contract. We're much assisted by Chitty here, and I have to say that the relevant chapter of Chitty is very helpful indeed, dealing with frustration. But what Chitty says here is the fact that the parties have foreseen the event but not made any provision for it in their contract will usually, but not necessarily, prevent the doctrine of frustration from applying when the event occurs. The inference that a foreseen event is not a frustrating event is only a prima facie one, and so can be excluded by evidence. Effectively, the crux of this event being beyond the contemplation of the parties really comes down to the knowledge, the expectation, and more importantly, the assumption of risk. We're assisted here by Trital in his work on frustration and force majeure. It's third edition from 2014, and I suspect going into the future we may well see a new edition of this coming out to deal with a lot of the issues that we're going to have to face in the coming years, dealing with the COVID-19 breakout. But what Trital says is foreseeability will support the inference of risk assumption only where the supervening event is one which any person of ordinary intelligence would regard as likely to occur, or the contingency must be one which the parties could reasonably thought to have foreseen as a real possibility. I'll get back onto the foreseeability side of things when we come to look at the COVID-19 effects and how that ties in with frustration, because I think this may well be an important and key term in some of those cases. You'll see at the bottom of this slide, I've referred to Herne Bay Steamboat Company Limited in Hudson again. That's the coronation case in which the steamboat was hired. They couldn't watch the review on the water from the steamboat, but they were still able to use that steamboat to go around for a nice cruise on the sea. I've used that as an example of a contract where it's required to go to the root of the contract. And in Herne Bay Steamboat Company Limited, it didn't quite go to the root because there was still that possibility of using the steamboat for another purpose and gaining some benefit from the contract. And it shows a little bit of the blurring of the test, if you like, between the radical difference in obligations and this concept of something that strikes to the root of the contract. Now, the final stage of our frustration test requires that neither party is at fault. And I find a very useful case in dealing with these issues comes from the superservient 2. That's the case that I referred to at the beginning of the presentation. The superservient 2 assists us with two concepts that are important in frustration. The first is this concept of self-induced frustration, and the second is the relevance of negligence. Now, the facts in the superservient 2 are that the parties agreed for the transport of a rig, and the company that was going to transport the rig had two ships. It had the superservient 1 and the superservient 2. The contract between the parties did not specify which of those two ships was going to be used. The contract effectively said, you will transport my rig. And the use of either the superservient 1 or the superservient 2 was entirely at the discretion of the owners of those vessels. Unfortunately, the superservient 2 sank, and it couldn't be used for the purpose of transporting the rig. The owners of the vessel sought to claim frustration of the contract. And it's not uncommon in admiralty cases for vessels that have sunk or been destroyed to result in frustration. The court looked at this point from the perspective of what it called self-induced frustration. And it came to the conclusion that actually it was by an election of the owners of the vessel, which vessel they would use to transport the rig. And therefore it was their election which of their various contracts they would breach. They chose to use the only remaining superservient, the superservient 1, for other contracts. And therefore they chose to let down the party in this contract. And by that choice, they were restricted from being able to rely upon the doctrine of frustration. Now, the reality is that they only had limited and scarce supplies. They had customers for 2 vessels, and they only had 1 to comply with their obligations. So the reality is that whatever happened, as part of their election, they would have let somebody down. That person would have taken action against them, sued them for damages, for breach of contract. And if you're prevented from relying upon frustration, then those breach and those damages would follow. It might seem a little unfair, but of course we have to remember that the courts are sort of very careful in the use of the doctrine of frustration, and they don't want to undermine, in one of these respects, the freedom of contract. Now, if the parties had specifically referred to the superservient 2 as being responsible for transporting the rig, then in those circumstances, the contract would clearly have been frustrated because the superservient 2 wasn't available. So it might seem like a rather unfair approach, but it's certainly one that the parties could have anticipated and dealt with in their contractual relationships. Now, another important aspect of the superservient 2 is that it confirms that a party will be at fault for the purpose of the frustration test if they are negligent. And there was some debate about whether negligence amounted to fault within the whole frustration context. This was certainly cleared up following the superservient 2. So if the supervening event that has caused the problems within the contract that might not have been foreseen by the parties has been caused by the negligence of one of them, then that person clearly can't rely upon frustration to avoid their obligations. This brings us on now to the consequences of frustration. The consequences of frustration at common law would have been that the contract, as we've heard from Lord Bingham at the very beginning, would have been killed off. Obligations going forward would have ended. This caused all sorts of problems where you'd had people making advance payments and paying deposits, where some services had been provided but not been completed. The common law took a very harsh approach to this and effectively relied upon concepts of lack of consideration and failure of consideration. Those problems were reduced to a degree by the House of Lords in 1943. But following that House of Lords decision, we found that statute had stepped in to effectively assist with the consequences of a frustrated contract. And it did that by passing the Law Reform Frustrated Contracts Act 1943. That act applies to contracts that are governed by English law and that have been rendered impossible of performance or otherwise frustrated. The act doesn't contain any definition of frustration. It doesn't change the law on frustration. And so the test that we've advanced earlier remained the test. And the principles that were set out in the definition of what amounts to a frustration remain the same. The purpose of the 1943 Act was to deal with the consequences of frustration. One of the things that it looks into is the recovery of monies paid in advance. And it allows monies paid in advance of the intervening or supervening event to be recovered. That's under section 1, subsection 2 of the 1943 Act. However, the recovery of prepayments or advance payments is subject to a potential deduction for the expenses that have been incurred by the person who's received those payments in fulfilling the contract. Those expenses will only be recoverable to the extent or to the full amount of the advance payment. So if you made an advance payment in a contract of £100,000 and you've made an advance payment of £20,000, the most that can be recovered by the receiver of that £20,000 for their expenses would be the £20,000. So if they'd incurred £40,000 worth of expenses on the basis of your £20,000 worth of deposit, the legal approach would be, well, actually, that is subject to your contract. That is a risk that you have assumed as part of your freedom to contract. But what we see in respect of the application of the recovery of expenses is that it's at the discretion of the court. So you're not automatically entitled to all of your expenses. The court may award those expenses. And the basis on which the court awards those expenses is what it considers to be just. So it's a very wide ambit of how to assess these expenses. And there's been a fair amount of debate as to how it should be dealt with. So, for example, the court might say, this is a supervening event. Neither of you anticipated it, neither of you foresaw it, neither of you put any provisions within your contract to deal with it. And so therefore the risk should be allocated equally between you. So you'll only get half of your expenses back. Another way that the court could deal with it is to say, well, actually through the process of case law, through the process of statute, the statute provides that you can recover your expenses, so therefore you should be entitled to all of your expenses back. The reality is the courts have adopted a process that's somewhere in between. This was approved in Gameco SA and ICM, Fair Warning Agency Limited, in which the court said, well, effectively, it can proportion it as it sees just and fair. You might get 100%, you might get 25%, but the court will look at all the circumstances of the case, and that kind of ties in to the multifactorial approach that's being put forward as the concept behind frustration. So the 1943 Act deals with the recovery of payments that have been made in advance. It deals with elements of expenses. It also deals with obligations other than to pay money. And this is a situation where if during the course of the frustrated contract, you obtain a valuable benefit, that valuable benefit should be accounted effectively between the parties. And the way that's accounted is that court will identify what benefit's been received. And so the benefit might be a specific thing, which would be, for example, a building that has been partially constructed, or that benefit might amount to the services that were involved in the provision of something that wasn't quite completed. And it falls down to the court allocating the principles through justice to determine whether it's going to value this benefit in accordance with the services provided or in accordance with the end result. Once it's identified the benefit, it values it, and then it will award a sum that is just in all the circumstances. So it's coming back to this concept of justice. And I think that what we see in the frustration cases is that justice plays a very, very important role all the way through. We see this in the tests that have been provided for. We see this in the definition that we had from Lord Justice Bingham at the beginning. And now we see it in the consequences of frustration in the 1943 Act, is that the basis of the frustration principle and doctrine seems to be born from a requirement to do justice and to do fairness between the parties. It's interesting, within the 1943 Act, there is also a possibility of severance. So if your obligations within your contract can be broken down into specific particular areas. So you do this for me and I pay you this, then you do this for me and I pay you that. If the provision of those services are completely distinct and one element of the contract has come to an end, then severance will take place, and the work that's already been completed and done, been paid for, or is due and owing, will be severed from the frustration process, and the parties will be able to benefit from the obligations and duties running from that particular element of the severed contract. And it'll only be the rest of the contract that is then rendered or killed off, effectively, as Bingham would say, by frustration. So this brings us on to some consideration of how frustration is going to be affected by the current circumstances in COVID-19. I've indicated here that these are unprecedented events. What we've got, I think, here is a situation where two strands effectively have come together to cause all sorts of problems. The first strand is the disease itself. And the second strand is the efforts that have been undertaken by governments all over the world to a lesser or greater degree, quicker or slower, is all part of the controversy. But nonetheless, the vast majority of the world is currently on some form of lockdown. And the impact of all of this in terms of commerce and in terms of our daily lives is obviously that the disease itself causing illness and fatalities. Workers, key workers, directors are going to be unable to attend work. They may die and never be able to comply and complete contracts for the provision of their services. Interestingly, there's the illegality point that's come in this, illegality of gatherings, the early stages of lockdown, and the imposition of fines for people who breach social distancing. There's obviously delay, there's reductions in supply, there are transport issues, services have been suspended or interrupted, parties have had to allocate scarce resources, and we're told that we may well be facing quite a considerable and serious recession. In all these circumstances, I've been racking my brain to think of any other single event in my lifetime that has had a greater effect than the COVID-19 outbreak. And I can't think of any. In fact, looking at modern history, there doesn't really seem to have been anything like this since the Second World War. And in the Second World War, of course, we had all the effects of people being conscripted to go to service. We had, many young men losing their lives. We had the effect of the bombings, of the Blitz. We had, obviously, all the interruption of transport and services and scarcity of resources. And so the similarities are great. There's also the legality side of things. During the Second World War, it was illegal to contract with alien enemies of the state. We've had some illegality issues coming in respect of COVID-19 in the very harsh, certainly at the beginning, social distancing provisions, banning gatherings, preventing things like concerts and sporting events. The aspects of the doctrine of frustration, I think, are going to be particularly relevant for COVID-19 are the illegality cases. As I say, we've had the Coronavirus Act that's come out. There's serious amounts of secondary legislation that's dealing with the powers of police officers to control gatherings, etc. There's also those coronation cases. The coronation cases were focused on a particular event, and the media industry, I understand, and in respect of media law, there's a lot of discussion about how these coronation cases will relate to the cancellation of concerts and sporting events. It goes beyond that, of course, as well, because in the coronation cases, it wasn't a specific term of the contract when that person said, I would like to rent your property for the day and watch the coronation. It wasn't a specific term of the contract that it was only for, for the purpose of watching the coronation. The courts will look at the obligations of the parties and look at the motivation behind it from an objective perspective to determine whether or not a particular contract was based upon a specified event. I think also within the COVID-19 issues, we're going to see questions arising in respect of delay and those charter party cases on interruption. So, universities are uncertain about what's going to be happening in the future. It may well be that the first term is cancelled or not made available, or students aren't required to attend, and there may well be interruptions of leases. There'll be delaying contracts naturally as resources in terms of not just raw materials, but labour, etc., has been affected by the whole lockdown process. One of the issues that I think might be of great importance moving forward is that of foreseeability. Now, contracts that were concluded 3 or 4 years ago aren't going to be subject to any real issues about foreseeability. But I think those contracts that have been entered into relatively recently may well have to be assessed carefully by the courts. If we look at the whole COVID-19 chronology, you'll recall that the first reports from China of a novo virus were arising in late November, early December 2019. The World Health Organization declared a global pandemic on the 11th of March 2020. And it was 8:30 on the 23rd of March 2020 that Prime Minister Boris Johnson announced the lockdown that we were going to have to endure in the UK. Now we come back at this point to the Canary Wharf case. And the Canary Wharf case was actually a Brexit case. The European Medicines Agency had entered into a lease of a property. The European Medicines Agency is a European Union body. And as a result of the UK leaving the European Union, it tried to rely upon the concept of frustration in order to avoid obligations within the lease. This was dealt with in an excellent and careful fashion by Mr. Justice Smith. I would really recommend reading this case, not just because it's one of the most recent cases we've had on frustration, but also because the conceptual basis and the definitions are so well set out by Mr. Justice Smith. But he focuses on this slippery concept of foreseeability that needs careful handling. And I think that may well be an issue for us in the coming months and years as parties seek to avoid their obligations under contracts as a consequence of frustration that they say is based on COVID-19. The other issues that we're going to see here are, of course, this fact and degree. It's always going to be the multifactorial elements that we're going to have to look in to see whether we've got over the step of frustration. And the court's going to give us some guidance on this, and we'll get a better idea of how carefully the courts are going to be restricting the frustration principles. And of course, then there is the onerousness element and perhaps a distinction that we're going to have to make between the effects of the lockdown on the one hand and the disease on that hand, and on the other hand, the effects of the recession that's going to come afterwards. And I think there are going to be areas where there is going to be a blurring in this respect of whether something has been caused by a consequent recession or whether it's been caused by a frustrating event. That brings us on to force majeure. The definition of force majeure we find very helpfully in Chitty. The expression force majeure clause is normally used to describe a contractual term by which one or both of the parties is entitled to cancel the contractor, or is excused from the performance of the contract in whole or in part, or is entitled to suspend the performance or claim an extension of time for performance upon the happening of events or events beyond his control. What we see here is that force majeure is effectively a creature of contract rather than being born out of the concept of justice And the justice is what we see as effectively with frustration. Frustration's roots are within justice. Force majeure roots are very clearly within contract. The scope of force majeure, you will often see specific events listed within contracts, and I've got a helpful section of Chitty that deals with some of the specified events that have been adjudicated upon by the courts. Chitty says, the following words and phrases have been the subject of consideration of the courts: act of God, storm, tempest or flood, fire, perils and dangers or accidents of the sea, war, warlike operations, civil war, riot, civil commotion, strikes, acts of the Queen's enemies, and the prohibition of export. Now, interestingly, we don't see anything in there about pandemics or lockdowns, but that's hardly surprising given these recent events, as I say, were clearly very difficult for us to anticipate. Force majeure clauses will typically specify particular events, but they'll also have a general clause, often referring to any acts that are beyond the control of the parties. If you've got a force majeure clause that kicks in many cases, it will lead to the exclusion of frustration, but not in all of them. So, for example, if one party has an option to suspend or extend a period of time as a result of a force majeure clause, but there is a catastrophic supervening event, the contract can still be frustrated. We need to look at the contractual terms for what I've described as a prescribed requirement. Look at what has to be affected by the specific event or the general event. Has it prevented the contract? Does it require the contract to be prevented from carrying on? In which case the terms are quite strict. It should be impossible to continue that contract, or not simply more onerous or less profitable. The next level down from being prevented is being hindered. A contract could be hindered if supplies are reduced, or a different approach needs to be taken to the contract that doesn't render it impossible. And then finally, that has a contract been delayed? Look at the specific terms of the contract in order to establish the issue of delay. The next thing is mitigation. When a force majeure clause is relied upon, the parties do have a duty to mitigate, and that is important to take the reasonable steps that can be used to avoid the negative consequences. Knowledge of events prior to the contract. There is some speculation about whether or not the foreseeability of it, of a particular event, if it was known or could have been known to the parties prior to entering into the contract, whether they should be allowed to rely upon force majeure clauses. I think the general feeling is that if it was known by one or both of the parties that a force majeure element was going to be almost inevitable or very reasonably likely to happen when they entered into that contract, then they will be struggling to rely upon the force majeure clause. Interestingly enough, insufficient goods. If you have insufficient goods as a consequence of a supervening event and you wish to rely upon your force majeure clause, it's not the same as the superservient to. If you have insufficient goods or scarce resources to distribute amongst a number of contractual parties who have entered into contracts with you under separate and different contracts, you will be allowed to distribute those goods in a fair way that complies with the way that may well be dealt with under your trade. So it might be a pro rata distribution, or it might be a first come, first served distribution, but you won't be effectively persecuted in the same way that you would have been under the superservient to. And then finally, in respect to the force majeure scope, Unfair Contract Terms Act and the Consumer Rights Act 2015 apply in consumer contracts and in commercial contracts, obviously in the 1977 Act, so that any force majeure clause should be reasonable. And I suspect that the tests of reasonableness will be something that will be dealt with quite regularly in the future as a result of this COVID-19. And the COVID-19 interrelationship with force majeure, there will be likely to be an increased reliance on force majeure clauses. So if you are involved in that, look carefully at the term, look at the effect, look at the mitigation that has been undertaken, and look at the fairness either under the 1977 Act or under the 2015 Act. So that's if you're in a contentious situation. If you're in a non-contentious situation and you're drafting boilerplate clauses, you might want to consider pandemic as being a specific event. And if you do that, I would suggest that you look both at the impact of the disease and the subsequent lockdown or quarantine provisions. So thank you very much for your patience as we've gone through the presentation. I understand that it's possible to open up to questions and you can type your questions through the chat facility. So if anybody's got any questions, please feel free to type them out and I can deal with them for you. Has anybody experienced any reliance upon frustration or force majeure clauses as a result of the COVID-19 relating to cancellation of events and payments of deposit? That's something that's dealt with in the 1943 Act as an advance payment. I think it's going to be very interesting in the way that companies who have arranged these very, very large concerts and sporting events will respond to frustration issues, saying we should be entitled to keep some of your money that's been paid in advance for our expenses. Now, you'll recall that part of the 1943 Act requires that the court to deal with this justly and gives it a great deal of discretion. So I suspect we're going to see a fair amount of case law coming in dealing with advance payments in respect of concerts and sporting events. The issue of postponing something will then come down to, has this event been frustrated? Has the contract been frustrated? So if it was a simple position of being able to say, okay, there's an interruption in my service, we will delay this and we will put this event on at a different time. A lot of that will come down to, I think, the availability of the person who has purchased the ticket. And you may well have to show that actually the new date that's been proposed isn't available for me, or it's possibly also as a consequence of my concerns with this disease, I don't want to attend any mass gatherings. But you will have to demonstrate in each individual situation how the contract has been frustrated as a consequence of the COVID-19. There's reference here now from Mr. Duke about a wedding that's not taken place, refusal to return the deposit, again falling into the 1943 Act. And unfortunately, it's going to look at the individual circumstances of the case because of the possibility of being able to recover expenses. A very interesting comment here from Miss Jane Ryland in respect of JCT contracts. Yes, I think it is going to be a question of when moving forward with force majeure contracts, in that there may well have to be adaptation of existing JCT contracts. I think it's unfortunate to say that, this may, the lockdown that we're experiencing now is likely to continue for some time. And it may well be, given how the world had at one point seemed very, very small, and we were able to move around and travel quite easily. I appreciate now that's not necessarily the case, but the possibility of pandemics coming into the future is also something I think that we need to consider. It would be a shame to be bitten twice, effectively, if we've not learned from our mistakes and difficulties that we've experienced here. Employment contracts, I'm not an employment lawyer, I'm afraid, so I won't be able to give specific advice on employment contracts, but employment contracts are specific services as far as a contractual perspective is concerned with the individual, and they are an individual contract, and it will depend upon the contract whether that individual could be replaced by somebody of his own choosing, or whether it is with that specific personal context. And frustration of employment contracts is common in respect, obviously, of sadly fatalities, but there is specific case law that deals with interruption of employment contracts as a result of illness and being unable to work. I don't know how that ties in with specific employment legislation, but from a contractual perspective, it's something that has been dealt with. But also interestingly as well, when you have an employee who's been sentenced to a custodial sentence, there's all sorts of case law in respect of those employment issues. I see a question from Mr. Parker about a settlement agreement for an occupier to vacate a property by a date. reached a court during a possession hearing and signed off by the judge, voluntarily agreed to vacate by that date, the court is going to have to take into consideration, even in any kind of settlement agreement, which is still obviously a contract, and settlement agreements, I would imagine even as consent orders from the court, can still be frustrated. It's going to be a question of the obligations under that agreement and whether they've been rendered radically different or impossible. So if it was impossible for the person to move out because they had nowhere else to go, that is certainly an argument I could see them putting forward to the court, and one which the court might have some sympathy for. But you'd have to look at all the circumstances, as I say, that factorial element that we see. Well, in that case, ladies and gentlemen, thank you so much for your time. I hope this has been of use to you. If you would like to contact me with any questions, you can do so on my email address, which is j.nickless@pumpcourtchambers.com. You can always call the clerks and we can have a chat about this. It's a fascinating area, and I think it's something that is going to evolve and develop over the next 18 months to 2 years, certainly. So thank you all very much indeed for your attendance, and I look forward to receiving any emails or comments that you may have.